Yade isnina she sanjikin initially turiji ni bashishin deshini dashiche ado sanjikin dashinale ado salau ba agati dahi beshaz anje atkah nashnish in lindo zisijin begolde ha ho zoigi begidin shindo besnashnish. My name is Tyson Yazi. I'm a Navajo Nation prosecutor, and this afternoon I'll be presenting on the Navajo Nation Health Civil Commitment Act. And today I'm presenting on two forums. There's the in-person forum here in Chinle. So we're in the Chinle Family courtroom here in Chinle, Arizona, and we do have a live audience. At the same time, I'm also presenting on the Facebook and YouTube channel of President Boo Nygren's social media platforms. So with that, we'll go ahead and begin. Adaho Desi, she Todigon Shwaliede De Nasha, Slay at Tordo, Kindaslachi, Bitkaki a Holia Quaege, Ado look until the Shiaho Gil Sweet Kake. Ako dadze nes na nachai akuta salauba got di dahin schlingo. So with that, my name is Tyson Yazi. I'm a Navajo Nation prosecutor here in Chinle and Zilthajin judicial districts. I've been a prosecutor for about 11 or 12 years in total. So the Involuntary Civil Commitment Act is actually a part of the Navajo Nation's exercise of tribal sovereignty. Just as any state government or any other tribal government has the ability or the inherent right to do so, the Navajo Nation also has the inherent sovereignty to protect the health, safety, and welfare of its citizens and communities. We did not always have our Civil Commitment Act in its present form. In fact, for the longest time since 1961, the closest resemblance of what we have today was what was called the Tuberculosis or Other Contagious Diseases Act. And this was in Title 13 of the Navajo Nation Code. And very simply, what that Tuberculosis or Other Contagious Diseases Act provided for was for the right or the ability of a person to petition a Navajo Nation family court to petition a person who was thought to be suffering from tuberculosis or any other contagious diseases to undergo a medical evaluation, treatment, and isolation if required. So historically, the Navajo Nation had only that statute, which was Navajo law between 1961 until 2006. And that was the closest thing that we have to any involuntary civil commitment statute. Following 1961, the issue arose in 2004 again when the Navajo Nation government petitioned for involuntary commitment of a patient in Kayenta Family Court. And there, although we did not have a formal statute to provides it, the Kayenta Family Court did accept the petition and involuntarily committed a patient to Flagstaff Medical Center for up to 60 days. And how the issue arose to the Navajo Supreme Court was when the patient challenged his holding or his commitment. And by the time it reached the Navajo Supreme Court for the Navajo Supreme Court to decide, the patient had already been released from custody, and therefore the whole issue of commitment was moot, and the Navajo Supreme Court did not establish any guidelines or did not formally accept a common law type of practice of accepting involuntary commitments in Navajo family courts. However, they did take note that there are currently, back then in 2004, there were currently no guidelines in place across the Navajo Nation that provided for any type of mental health commitment. And the Navajo Supreme Court went on to note that Navajo district courts could adopt procedures, rules, or the Navajo Supreme Court could also adopt its own separate rules, or the Navajo Nation Council could enact a law. So the Navajo Nation Council responded to that just 2 years later by enacting what we now know as the Navajo Nation Health Civil Commitment Act of 2006. This was enacted on January 24, 2006, and most importantly, what it did is it repealed the former Tuberculosis or Other Contagious Diseases Act that I first mentioned. And since it was enacted in 2006, the law remains just as it was enacted. It has not been amended, it has not been superseded, and to my knowledge, it has not been challenged in any way in any Navajo Nation court, including the Navajo Supreme Court. So it continues to remain in its form as was adopted by the council in 2006. Real briefly, there are different parts of the Health Commitment Act, and on the left side of the screen here, you'll see the anatomy of it. It begins with the policy that the Navajo Nation Council included, all the way through the definitions, the grounds that one may petition a Navajo Nation family court for the involuntary commitment of a person, what the Navajo family court could order in a health commitment order, and there are provisions about minors as well as emergency protective custody. Some important things to take note of is that a health civil commitment case filed in Navajo Nation family court is a civil case. It's not in any form a criminal case. So therefore, there is no incarceration, there's no arrest, there's no criminal charges, and most importantly, there's no required proof of beyond a reasonable doubt to prove these petitions in Navajo family court. Also important, the statute does provide that the Navajo Rules of Civil Procedure, as well as the Navajo Rules of Evidence, apply to all hearings in family court. So that tells you that there is some kind of format for the court to conduct a hearing. There's formal rules of evidence that would apply. For example, rules that concern the admissibility of certain types of evidence, hearsay provisions, and whatever proof that is required to be accepted into court, as well as foundations for that evidence that is presented, as well as rules concerning the scope that it's accepted into court, as well as the issues of probability and prejudicial concerns as to the proposed patient or the individual. Also important to note, the Navajo Health Commitment Act does guarantee the person, the patient, the individual, or the person that is subject to the petition, it does guarantee them rights, including the right to be represented by legal counsel, the right to be informed of the petition, adequate time to prepare for the hearing, the right to confront witnesses and evidence that is presented against the individual or the patient, and also the right to have an independent evaluation and the right to an impartial hearing. Translated into Navajo, Kweshindi Nalso Spaces Sozigi, Khashin Al Bensikis Badaho Egi Do, Inda Khait Al Shin Do Yat Eko and Sikisko, Ekutal Nalso Spaces Sozgo. A Behaz Ani Anigo A Kweshin Basis Sozigi A Hashin Sogo, Behaz Ani A Big Estkitla. Behas ani be begist ki egi agadit ahi shabike hodone nzinko babehas in the or ine dan linigi hats anje dan linigi or ini hats anje dan linigi nejdos kistole ligi ba ha hot Adonde hat injiko o enedan lenigi asto handa hodol nehigi asto ba ha hot kutao be has ani be begistiet khishi kutao not so special souls go. So in the Navajo Health Commitment Act, the Navajo Nation does state in its policy that uh, anyone who is a threat to the health or safety of either themselves or others due to a physical or mental illness or disorder should receive appropriate treatment in the least restrictive environment. So that's, in a broad sense, the overall policy that the Navajo Nation has in terms of uh, entertaining a petition for involuntary commitment in Navajo Nation family courts. Also included in the policy is the overall goal to restore the individual as well as the community back to hojo or harmony. And the policy also mandates that at every stage of a proceeding, from evaluation through the civil commitment, even through the treatment processes and reintegration into community, that at all stages, principles such as a job door, Hishim, Hishim, Bandahas Anigi, um, um, that they're treated with respect and treated with all fairness and so what is the purpose and the intent of the Navajo Nation Health Civil Commitment Act? The purpose is to balance the interests of the individual as well as the community when this person is suffering from either a physical or mental illness or disorder, and the untreated consequences of that illness or disorder presents a reasonable likelihood of serious harm. And the reason in this slide that I've highlighted reasonable likelihood of serious harm is that that is actually a legal term that is continuously repeated throughout the act. It's a legal term that is defined in the act itself and is an element that a Navajo judge and Navajo family court would look at in deciding whether to grant a petition for involuntary commitment or some form of treatment. And also important to note is that the act, Navajo Nation law says that the act is to be liberally construed to be consistent with the overarching policies that we covered a while ago. Also important, the act mandates some form of coordinated response from all entities of the Navajo Nation to work together in the best interest of the individual. This includes a mandated coordinated involvement from the Navajo Nation president, all the Navajo Nation divisions within the executive branch, departments, offices, programs, and even down to enterprises and other Navajo Nation entities. So the law requires us all to work together, including the director of the Division of Health, and the Division of Health Director is mandated to work with external agencies, which would also include outside governments such as states and other jurisdictions that might have an impact or be impacted or have an involvement. So one of the important questions to ask when looking into whether to file a petition for involuntary commitment is to question who can file. So the Navajo Health Civil Commitment Act does provide that an adult family member could file these petitions or applications. a legal guardian could file these petitions or applications, or any employee of a governmental agency. Next, the question becomes, when or why should I file this petition or application? The law provides that any of the three categories of people or agencies could file these petitions when that person or agency suspects that an individual suffers from either an illness or disorder, and as a result of that illness or disorder, presents a reasonable likelihood of serious harm to themselves or to the community. We'll get to that. Yeah. So the question here in the live audience was, where do we get the forms? But we'll go ahead and cover that at the end. So as I mentioned, this term is important because it's an element of the proof that the court will require at a hearing, as well as a definition that is defined in the act itself. So likelihood of serious harm, there are 5 different things or different situations that could constitute a likelihood of serious harm. Under the first scenario, likelihood of serious harm includes where a substantial risk of physical harm in the near future to the individual exists. So notice that the first scenario is harm to the individual himself or herself. And this substantial risk of physical harm could be evidenced or manifested by either threats of, attempts at, suicide, or other serious physical harm. So that's one of the grounds for likelihood of serious harm. Under number 2, notice that number 2, the scenario is a substantial risk of physical harm in the near future to other individuals. And that's evidence or manifested by either evidence of homicidal or other violent behavior, or evidence that others are placed in reasonable fear of violent behavior and serious harm. So the difference between number 1 and 2 is number 1, the scenario is substantial risk of physical harm in the near future to the person himself or herself. And then 2 is substantial risk of physical harm in the near future to other individuals. The third scenario of likelihood of serious harm includes some substantial risk of physical impairment or injury in the near future to the individual, as manifested by evidence that shows that the individual has judgment that is so impaired that he or she is unable to protect himself or herself in the community. And then number 4, likelihood of serious harm there exists when there's a substantial and serious threat of spread in the near future of some form of infectious illness, which has life-threatening consequences for a significant number of people exposed, and where the individual refuses or somehow is unable to comply with voluntary treatment or confinement procedures. Notice that this fourth option is basically the same as to what the 1961 law was as far as contagious or infectious diseases such as tuberculosis, or what we recently experienced, the COVID-19 pandemic. As to number 4, I do recall during at the height of the COVID-19 pandemic, this was seriously considered by a number of individuals within the government as to whether the Navajo Nation Prosecutor's Office or any other government agency would begin petitioning Navajo family courts to involuntarily commit individuals who were COVID-19 positive, who were refusing to self-isolate or quarantine or take measures to protect others from being infected. However, that presented problems. Obvious reasons why that would not have really worked to begin with is because there was not enough room within hospital settings to forcefully quarantine someone. And even if they were forcefully quarantined by court order to their own home, there were issues of who would enforce that type of in-home quarantining or isolation. And also because of lack of access to clean water, uh, many families understandably would not want their COVID-19 infected relatives to be quarantining or isolating themselves in the family household, especially if the rest of the family was at risk or was not infected with COVID-19. So in a nutshell, number four, as likelihood of serious harm, it's infectious illnesses such as tuberculosis or COVID-19. And in my experience as a prosecutor, I do recall one time utilizing the fourth option for a patient who was infected with tuberculosis and was refusing to take medication that would have addressed the tuberculosis problem and was at risk of coming to a point in his illness that he could not be treated by ordinary medication if he continued on his path. So there, we had to petition the family court here in Chinle to court order the individual to stay in the ER or the hospital here in Chinle in order to be medicated. And then eventually, when they were safe to go home, we continued on to court order them to comply with the social worker or the medical personnel that would come to his home from the hospital in order to continue administering medication to fully address the tuberculosis problem. So that was successful as to number four. And then lastly, Navajo law also includes likelihood of serious harm. Uh, the definition to include a pregnant woman whose ongoing substance abuse presents a substantial risk to the unborn child. And this especially arises in cases of child abuse or neglect cases where there's a pregnant mother who is expecting at any stage of her pregnancy and for whatever reason is using what is commonly seen around here, methamphetamine or even drinking intoxicating liquor. So notice that even for that type of situation, although it's not some form of mental illness or physical harm to the mother herself, there the focus is on the unborn child and the safety of that unborn child. So that's also a situation where this Health Civil Commitment Act could be employed. So after you get through the definitions of likelihood of serious harm, next comes the question of what exactly is the law? So the Navajo Nation Health Civil Commitment Act allows for two things to be asked of a Navajo Nation family court. The first thing is an involuntary assessment or some kind of evaluation. And then, depending on that evaluation, if necessary, an involuntary treatment could be some form of involuntary commitment to some kind of facility, or it could be simply court ordered treatment in the community, such as in an outpatient treatment facility, or even in the hospital, as was the example I provided, or even in the home, in the individual's home. So the Navajo Nation all across the reservation has 11 judicial districts. And we are in the central part, which is Chinle Judicial District, as well as just to our west, the Jislijin or Pinyon Judicial District. So for any IHS personnel or workers who are employed at Pinyon Health Community Center, just know that you do have a local Navajo Nation family court. It is directly north of the Pinyon Chapter House. It is directly north of the Pinyon Chapter House, and is able to accept petitions for involuntary commitment or applications for court-ordered evaluations. And then obviously the IHS facilities around Chinle, including Chinle IHS, Sayle, or even Red Rock Point, I believe. Chinle would be the local family court here. So there are basically two steps in an involuntary commitment process. As I mentioned, the first step is the application for evaluation, and this application must include enough facts in order to show the judge by clear and convincing evidence that the individual's behavior, illness, or disorder presents a reasonable likelihood of serious harm to himself, herself, or to the community. The application is filed with the Navajo Nation Family Court as an ex parte filing. And ex parte basically means that there's not a requirement to give notice to the proposed patient or the individual. Uh, and they don't even need to know that the person has filed this application. And the court could also grant the court-ordered evaluation ex parte, without notice to the individual. And in this application, you're asking the family court to order the individual to be held in the least restrictive environment and also to undergo an evaluation. You must also identify one healthcare professional who will conduct the evaluation, and then also a second healthcare professional who will concur in that evaluation, including the date and location of the evaluation. And you'll see in a while why I took great care to highlight healthcare professional, because that is a legal term that is also defined in the act itself. The application must include, as I mentioned, enough facts to convince the judge that the individual is a danger to himself or to the community. And this is usually based on personal observation, and the personal observation or the facts must show the judge and convince the judge that the individual presents a likelihood of serious harm. It must include a statement of the specific nature of what that serious harm is. It must include a summary of the observations upon which the statement of serious harm is based, and it also must include a signature. Notice that in the requirements of the Act, as I mentioned, least restrictive environment, that is actually defined by the Act to include and to vary depending on whether the individual is a danger to themselves or a danger to others. So based on those two scenarios, the least restrictive environment would mandate that they either be held in some type of environment that is the most appropriate and therapeutic setting, which is no more restrictive of the patient's physical or social liberties than is believed conducive to the most effective treatment for the patient. So that's on the left side, where the individual is a danger to themselves. And then on the right side of the slide, where the individual is a danger to others, there the least restrictive environment would be some kind of setting where treatment is available and where the risks of physical injury or property damage is warranted by the proposed plan of treatment. And treatment can be in a home or a community setting or in a local medical or treatment facility as close to the individual's home as possible. So that's in a nutshell the Act's definition of what least restrictive environment is. Important to note, the Act specifically states that least restrictive environment does not include detainment in a correctional facility, so it does not include a jail facility. As I mentioned, the Act specifically defines what a healthcare professional is. And there are two main components to this definition. So, healthcare professional is a practitioner who has an active state or Navajo Nation license and who works in a licensed healthcare delivery setting or program. So, that's all the Act defines for healthcare professional. Notice that it does not specifically require a medical doctor or any other specialized doctor. But in situations where the basis of the involuntary commitment is the individual is a danger because of a mental illness, not a physical illness, but a mental illness or disorder, then the law requires that one of those two healthcare professionals must be either a clinical psychologist or a psychiatrist. Next, the evaluation, if it's granted by the family court, must be completed within 7 working days after the court order. It must also consist of an assessment of the patient's history, the presenting signs and symptoms, the medical exam, necessary laboratory or psychological testing, and most importantly, it must arrive at some opinion by a healthcare professional on the patient's condition and treatment recommendations. So following the evaluation, if there's an opinion by a healthcare professional that the individual is suffering from some form of diagnosis and presents a reasonable likelihood of serious harm, and the opinion also recommends further treatment, then you could follow up with step 2, which is actually filing the petition for treatment. The petition for treatment itself must contain names and addresses of the individual to be treated. It must also include name and address of the person who is filing the petition, whether that's the adult family member, whether it's the legal guardian, or as I mentioned, any employee of a government agency. The petition must also identify what illness or disorder that the individual or the patient is suffering from. It must include a brief statement of the observations describing the individual's communication, behavior, or actions occurring as a result of that illness or disorder, which again presents a likelihood of serious harm. It must also include the least restrictive treatment procedures that are available. And most importantly, it must include signed evaluations by the two healthcare professionals who one of those healthcare professionals is the person who conducted the actual evaluation, and then the second healthcare professional concurs in the first evaluation. And as I mentioned, if the basis for the involuntary commitment is some form of mental illness or disorder, again, one of those healthcare professionals must be a licensed, a clinical psychiatrist or a psychologist. After filing the petition, you will need to get ready for the court hearing itself. As the petitioner, as a person that is filing this petition, you must be sure to include the evaluations. You may hire your own attorney or advocate to litigate this petition on your behalf. You must also be responsible for notifying your witnesses and gathering whatever evidence is necessary to present at the court hearing. On the other side of the spectrum, the individual, the subject of the petition or the application, at this point of the stage of the proceedings, because it's a petition for treatment and because the court will be going into the actual hearing itself, there are due process concerns that would apply. For example, the individual must be served with the petition and the evaluations. They must be notified of the date and time and place of the hearing, and they must also be advised of their rights. And those rights include the right to be represented, including by court-appointed legal counsel if they are indigent, and they must have the right to have adequate time to prepare for the hearing. They have a right to confront witnesses, and they also have a right to a fair and impartial hearing. So we do have, I'm told we have a couple of questions here. We do have 25 minutes to go and about 15 more slides to go, but I will entertain the questions. So the online questions is, good afternoon, watching from Totonese. This needs to be revised and communicated to all districts. There are minors that need help, grandparents and parents don't know or need to be educated concerning the rules. Okay. This needs to be educated all throughout Navajo Nation. Watching from Alamo, Navajo. Hello. Is this a Fourth Amendment violation? Just asking. It could be, but at this point, the issue has not been raised or has not been challenged in Navajo Nation courts. As I mentioned, the statute continues to be in its present form as it was enacted in 2006. Since then, there's been no Navajo Nation Supreme Court case laws that has struck down any provisions or has interpreted any other provisions differently. Know that it's not, it's the standard of care in all states in the US. Okay. All right. Next, continuing on with the slides. So after you are getting ready for the hearing, one of the important things that you must consider as a petitioner, whether you're representing yourself or whether you're a doctor that's employed by a hospital who's filing this petition, or whether you're, in our case, a prosecutor who is filing this petition, or even a jailer or police officer filing this petition, or a social worker, whoever you are that is filing this petition. Once the Navajo Nation Family Court schedules a hearing, as I mentioned, it's your duty and your responsibility to notify your witnesses, bring your witnesses to court. And as is true with most Indian tribal governments, the only healthcare facilities that are mostly available, including in Navajo Nation communities, are IHS, federal government hospitals. And IHS is a part of the federal US Department of Health and Human Services. And because they are a federal entity, federal agency, they typically, because of federal law, they typically will not voluntarily appear at and testify in Navajo Nation family courts, even if they are properly served with a subpoena or a Navajo Nation family court order that requires them to appear. And they're not allowed because of their employment. Now, the way to get around this is actually provided in the Code of Federal Regulations at 45 CFR section 2.4. And basically, the CFR provision requires that the person that is seeking the IHS government employee or doctor's testimony and presence in tribal court to submit a written request to the local IHS administrator. This could be the chief medical officer at the IHS facility. It could be the risk manager and the IHS Navajo area director. So those are the two persons that must be given a written request. And what goes into that written request? Obviously, you have to cite 45 CFR 2.4. And the elements are stating, you must state the nature of the requested testimony. You must include why the info that you're requesting is unavailable by other means. And you must include reasons why the testimony would be in the interest of the US Department of Health and Human Services or the federal government. And a tip for anybody who is filing these petitions is to invoke what is the purpose of IHS. Uh, the purpose of IHS is to treat Navajo community members, to treat those that are sick either from a physical or mental illness. And this is basically what we're doing is trying to further the IHS goal of treating sick individuals or those that are in need of some form of treatment involuntarily. So that's the only way you're going to get the IHS doctor, the IHS psychiatrist, IHS psychologist, the ER attending physician, the nurse practitioner, psychiatric nurse practitioner. That's the only way you're going to get them to testify in Navajo Nation family courts, by going through the process of submitting that written request to IHS as well as the local area Navajo IHS office, and specifically invoking the CFR provisions and fulfilling the elements. So the court hearing, once you get to the Navajo Nation Family Court scheduling a court hearing, it is closed to the public. There is no jury trial. This is simply decided by the judge himself or herself. As I mentioned, as a petitioner, you carry the burden of proof. You must prove by clear and convincing evidence that the individual suffers from an illness or condition, and as a result of that illness or condition, that the individual presents a reasonable likelihood of serious harm, either to themselves or to others. On the other end of the spectrum, again, the individual has rights, including right to be represented by legal counsel. So most often, Navajo Nation family courts will, by standard practice, appoint an individual legal counsel utilizing the Navajo Nation Judicial Branch's pro bono appointment list. So most often the individual will have legal representation. And because they have legal representation, you can expect that the individual's legal counsel will challenge the petition and will utilize the Navajo Rules of Civil Procedure and the Navajo Rules of Evidence to insist on and represent the individual's best interests and rights at this hearing. So if you're a person that has filed this petition pro se on your own, and if you've not gone through the process of invoking 45 CFR 2.4, or you've not notified the Navajo area IHS, or you've not prepared to bring your witnesses and evidence, then you can expect that the individual's attorney or advocate will motion the court to dismiss your petition and probably will succeed in doing so. So the individual also has a right to participate in the hearing. Family members of the individual may be present, and the individual by law is required to be treated with all due respect and dignity throughout this process and in the hearing. And also important to note, the individual has a right to an independent evaluation that is separate from the evaluation that is conducted by the two healthcare professionals for the purpose of the petition by the petitioner. Real quickly, as I mentioned, the petitioner carries the burden of proof. And in Navajo, this burden of proof is defined as adahuintingone be ehozini be achinje nehodot ashko ischane dol nis asalai. So that burden of proof is on the person that is filing this petition. And there are different levels of burdens of proof in any type of court case, including in Navajo Nation family courts. At the highest level is what's called the beyond a reasonable doubt standard. And this is employed and applies in criminal cases where the prosecutor's office is charging a defendant with a crime. And then at the lower level of the court standard of proof is what's called the preponderance of the evidence. And one way to memorize what preponderance of the evidence is, which is the civil standard, is thinking of a justice scale and slightly tipping the justice scale slightly in your favor in order to prove your allegations. So that's the civil standard. But in between the beyond a reasonable doubt standard and the preponderance of the evidence standard, in between there is a clear and convincing standard. And that standard applies in Navajo Nation health civil commitment petition hearings. So after the family court conducts the hearing on the petition, and provided that the judge has granted the application, Beishjane Dolnihli Pohone Ango, after the hearing, after the judge finds by clear and convincing evidence that the individual suffers from an illness or condition which causes the individual to present a reasonable likelihood of serious harm, then the family court may order him or her to undergo a course of treatment. Again, the course of treatment must be in the least restrictive treatment procedure available, and to the extent advisable, it must also include traditional native healing methods. The least restrictive treatment procedure is defined by the Act to include a course of treatment that provides the maximum freedom to the individual while also protecting that individual and others or both from that individual's behavior, illness, or disorder. Again, it does not include a jail type of placement, and it must be as close to home as possible. Also, the family court health commitment order uh, does provide for transportation of the individual. It also includes some form of long-term discharge or other treatment plan. And under Navajo law, it must be reviewed by the Navajo Family Court at a minimum every 120 days, or it could be much sooner, such as 30, 60, or 90 days. Just no more than 120 days periodically. And at any time, even before a review hearing, if there's a treating healthcare professional who determines that commitment is no longer necessary, then the individual can be released by petitioning the court for early release at any time. Otherwise, the individual would be released until that family court order expires. Some other important provisions of the Health Commitment Act includes language about guardianship or conservatorships. Now, these are not permanent types of relief that are available in the Civil Commitment Act. It's only temporarily so long as this health commitment order is in effect. Now, the court temporarily can appoint a temporary guardian if the court finds clear and convincing evidence that the individual is no longer capable of protecting himself or herself or their property. Or the court may appoint a conservator who acts as a fiduciary and accounts for the individual's property and other resources. If the court does appoint a temporary guardian, that temporary guardian is involved in all medical discussions and decisions that are made for the individual's benefit. And again, it's temporary, it expires either on the expiration date that is specified or when the health commitment order expires either on its own or by court order. Another important provision in the Navajo Nation Health Civil Commitment Act is emergency protective custody. So as I've been repeatedly emphasizing about how least restrictive environment does not include a jail, this is the only portion where jail could potentially come into play. Under the Navajo Nation Health Civil Commitment Act, emergency protective custody is available if the individual presents a reasonable likelihood of serious harm, and if we're outside of the regular court hours, and the regular court hours are Monday through Friday, 8 to 5 p.m., or if the individual needs emergency care. Then, if you meet those provisions, the individual may be held for up to 72 hours in the Navajo Nation Division of Public Safety's custody. Now, important to note, Navajo Nation Division of Public Safety includes the Navajo Police Department, it could also, for our purposes here, include the Navajo Nation Department of Corrections. The 72-hour emergency protective custody does not include, or maybe phrased differently, it excludes holidays and weekends. And during this 72-hour period, we have 10 minutes left. During this 72-hour period, either the application for evaluation must be filed with the family court, or if you've already gone through the evaluation, or you have some form of evaluation that meets the law's requirements, then at this time you can file the petition for treatment before the 72 hours is up. Once the 72 hours is up, then the Division of Public Safety will release the individual from the 72-hour emergency protective custody. So who makes this determination? Based on my experience, what I've seen, if law enforcement comes into contact with a person that's presenting reasonable likelihood of serious harm, and if the mandates of the emergency protective custody are met, then the law enforcement officer will typically transport the individual to the local ER, and the ER will examine the individual. And the ER doctor is typically the person that the jail, Navajo Nation jails, recognize as having that authority to request this 72-hour emergency protective custody, which is usually in the form of written request or some form of medical clearance form. And the law enforcement officer typically will bring that form down to a local jail when the individual is delivered to the Department of Corrections. Also important under the emergency protective custody provisions, it does provide that law enforcement officers may detain and transport the individual for emergency mental health evaluations and emergency care, even without a family court order, only if the individual is otherwise lawfully arrested, or if there's all of those remaining four provisions, which is that reasonable grounds exist for the officer to believe that that person has just attempted suicide, and based on the officer's observations and investigations, that officer feels that there's reasonable grounds to believe that the individual presents a reasonable likelihood of serious harm to self or others and requires immediate detention to prevent other harm. And the officer, upon arrival at the evaluation facility, is interviewed by the admitting physician or designee to provide info regarding need for emergency protective custody, and the healthcare professional certifies that as a result of a mental illness or disorder, that the individual presents a reasonable likelihood of serious harm to self or others and requires emergency detention to prevent such harm. So you would think that it all ends there, but for purposes of cases, petitions for treatment involving mental illness or disorder, there is no facility on the Navajo Nation presently and historically that could offer this type of acute psychiatric placement or long-term psychiatric care. They're only available off the reservation. And for us on the Arizona side of the Navajo reservation, we have usually, which is usually utilized, the Arizona State Hospital. And because it's a state entity and it's located off the Navajo Nation, they have their own requirements. And that gets us into the domestication and recognition of tribal court orders in state court. So Arizona's one of the states of the three states that Navajo Nation extends into that has a pretty well established procedure, because it states in both its state law as well as in its state court rules of procedure the process to domesticate a tribal court, family court order into state court. So in a nutshell, the requirements are that once the family court has issued its civil health commitment order, then the petitioner in the family court case must get a certified copy of that family court order and must file it with the clerk of the superior court that is locally. So if you're in Pinon, On the reservation in Pinon, the local superior court would be in Navajo County Superior Court. If you're in Chinle or Ganado or Window, the local superior court would be Apache County. And then if you're in Tuba City, then the local superior court would be Coconino County Superior Court. So upon registering this family court certified order with the Superior Court, uh, you must also provide notice to the State Attorney General's office, and the State Attorney General has 5 days in order to challenge the sufficiency of the tribal court commitment order. If the AG, State AG, does not challenge, then by operation of law, the State Superior Court will formally adopt and recognize the tribal health commitment order as an enforceable State Superior Court order for use in state facilities. Important to note, the rules of recognition in state court require specific findings. Due to the shortness of this presentation, I did not include all those findings, but just know that there are findings that would have to be made at the family court hearing, as well as be included in the family court order to be sufficient for state recognition. On New Mexico side, there is no formal New Mexico statute that I could find that would apply for recognition of adult health commitment orders, but there is a provision in state statute where a tribal court order could be enforced in state court for the commitment of a child who is subject to a health commitment in tribal court. However, as I mentioned, although there's no state statute separate for adults, there is the New Mexico Supreme Court adopted format for tribal court orders, which would apply for 30 days of treatment, which could be used if, for example, the Crown Point Family Court or Rama Family Court, Shiprock Family Court were to issue a health commitment order for an adult, that could be used as well. 3 minutes. Okay. Utah, I could not find anything in Utah, either in their state laws or their state rules of procedure, that would guide us as to how, for example, a person that is petitioning the Aneth Family Court on a Navajo reservation to recognize and domesticate that tribal court commitment order in Utah State Court. So that has yet to be seen. Lastly, I'll end on this slide. The Navajo Nation Health Commitment Act does specifically define individual as either an adult or minor child. And then also our law, the Hazani Act, Section 1004, also empowers Navajo Nation family courts the authority and jurisdiction over commitment of mentally ill or mentally disabled children. However, from what I've seen in our practice, this is mostly unnecessary, and I've never heard of an involuntary commitment in Navajo Nation family courts of a child, only because by definition, a child is unable to make their own healthcare directives or decisions, and most often their parent or legal guardian would be in favor of the child in need of services to be consenting to that treatment. So there, at least parents or guardians would have that authority. I would imagine this would arise and become necessary in instances where the parent or guardian is against treatment of that mentally ill child. So that's a situation where it might become necessary to file a separate petition. And we have 1 minute left. I'll quickly turn to the online comments. I do apologize as to the speed that we rushed through this. Who has any money for legal counsel, anxious employees and family members? There is a comment that the family court takes years to have a hearing. I forgot to mention the Navajo Health Civil Commitment Act mandates that these types of hearings be expedited, so they are prioritized in Navajo Nation family courts. So thank you, audiences online and audiences here in person, for your attention. I do apologize for the speed that I've had to go through all these slides. There are 40 slides, and I will resort to the host to be able to display or make available these slides in a more public forum separate from this. Um, Thank you.